Well, good morning, everybody. I think it's about time to get started. I apologize for the weather for those of you who are from out of town. It seems like every time the cherry blossoms come out, we suddenly get rain and wind, so they don't last very long. And I hope you didn't get too wet coming from the shuttle. Well, we're going to do panel 3 now, which is legal and institutional changes necessary for collaborative governance. And I'm going to be the moderator and give Phil a break so he can prepare for his big address at 11 o'clock today. So we have till about 10:30 for this panel, plenty of time for audience participation. We're going to start with, I guess they're in the order that they're going to be speaking. First, Don Arbuckle, who is now the clinical professor of public administration at the University of Texas at Dallas. But he's known to us as a longtime key staff person, career staff person in the Office of Information and Regulatory Affairs in OMB. And after Don, Bob Durant, who is a professor in the School of Public Affairs at American University. And after Bob, another distinguished professor of public administration, David Rosenblum, who is the co-director of the Center for the Study of Rulemaking. So I'm going to be the moderator. I'll try to have a light touch here and give the audience a lot of chance to ask questions after the speeches. Don?
Well, I appreciate the opportunity here to respond to the scurrilous misrepresentations of my office and the implied criminalization of myself that some members of the panel and organization of this conference have perhaps led you to believe. So,
the transcript reflected that was a joke.
I come to talk to you with what I have always thought, in a bizarre sort of way, is without the burdens of first a long or deep academic and scholarly knowledge of this subject. I come without the burdens of being a lawyer either, without legal training, which allows me to think like a normal person upon occasion, and also without the millstone of even greater millstone of being trained as an economist, who are so far out to lunch about how the world actually operates that I hope to be able to offer some comments here about collaborative rulemaking. So I'm going to talk to you about my experience at OMB, which made up almost all of my federal career. I started at OIRA in July of 1981, just a few months into the creation of that office, and I left in 2006, midway in the second term of the Bush administration. So I was in OIRA for 4 presidents, 7 terms, 11 directors, 8 OIRA administrators, and 3 other colleagues as deputy administrators. But who's counting for that sort of stuff? So what I want to do to start off today, I want to put in a good word for delay and deadlock and gridlock and ossification and regulatory malaise. These have been given a bad name by many of those supporters of collaborative governance. So I'm going to defend them for a little bit until I get jumped on by others. But these, of course, are the symptoms that the collaborative governance is designed to, or the weaknesses in the regulatory system that collaborative governance is designed to repair. So one of the impediments to collaborative governance is the Constitution. It doesn't have to be an end, a dam that totally prevents the flow of talking, but it does establish a system which we have developed over the last 200 plus years, which is based on a couple of principles that are so ingrained in the government now that it's hard to see how they can easily be broken. One of those is, of course, debate and argument. The Constitution sets up of course, a representative democracy. It recognizes that interests or factions will be competing for access and for authority, for power, for influence over the elected officials. And partly as a consequence of that and some other reasons, the gentlemen that cooked up this system were very skeptical or very worried about an excess of executive power. They were balancing that, of course, with the need for a strong central executive at the same time, but they were careful to set up a system where there were a number of rather permanent tensions built in. Those are the obvious ones, the tension between the House and the Senate within the Congress, and then a more fundamental tension between the executive branch, the presidency, and the Congress. And part of the point that I want to make to you about that is that tension is very real and alive and very well. And in the White House itself, it is a fundamental aspect of just about all behavior every day. Everybody in the White House is very aware of the president's authorities and trying to protect those authorities, sometimes to ridiculous degrees, but nevertheless, that is so fundamental a part of life in the White House that when the White House staff, and that includes OMB and OIRA staff, although I know Phil tears his hair out his thinning hair, his remaining hair, when I mention this, OIRA and the rest of OMB very much thinks of itself and is treated as an agent of the president, a direct agent of the president. It has some other roles too, but that is very much the way that we looked at ourselves and our job. And we were in close contact with the upper levels of the White House so that they knew that we were representing them and vice versa. That's not always clear to the public because one of OMB's roles in life is to say no when the president doesn't want to say it or the presidential aides don't want to say it. So OMB is happy to, as a general matter, to be blamed for things that the president himself or the upper-level White House have decided, but would prefer the director of OMB or the staff of OMB to be the agents of that decision. So the consequences of this from the point of view of the White House are that argument and debate, and to some extent those extensions of those, delay and so on, are parts of the daily life of the White House. I'll come back to this a little bit. Now, of course, just to mention a couple of other things, another one of the reasons for delay anyway is the simple complexity of so many of the policy issues that reach the White House. Now, this, of course, was something that other people have mentioned yesterday, but almost anything to do with the Clean Air Act, for example, is complex. It's complex technically, it's complex legally, it's complex politically, it's complex economically, and it's almost impossible to conceive of those complexities being worked out without people coming to loggerheads. And working that, as the people that have described collaborative governance have made clear, the working out of those, through those complexities is part of what a good collaboration has to do. You can't hurry that. One of the points that was made, perhaps by Jeff, by others, is that at the beginning of that collaboration, people just have to get used to being in the same room with people that they have been happily vilifying through their print media and other ways of communicating. When you're right next to somebody else in a room, it's much more difficult, and that's part of the whole reason that face-to-face dialogue is so important. So that care that needs to be taken for public policy needs to create some of this symptom that collaborative governance is designed to fix. Although, to be fair, collaborative governance doesn't argue that it can operate quickly and fix things in a jiffy. It acknowledges that. And then finally, I want to just add a note of context. Yesterday, Rena talked with some passion about how despondent she's been. I hope not clinically despondent, but despondent in an intellectual way at being faced with the last 8 years and the degenerated state that the regulatory system has fallen into. Well, I would just like to remind you all that in the middle of the 1980s, in the sort of into the Reagan first term, when OIRA was there making a mockery out of the regulatory system, taking away powers that Congress had in their dealings with the agencies, and I will acknowledge acting in many inappropriate ways in those early days that had to get worked out. But there was a considerable amount of despair at that time among the people who were despairing today as well. And then in addition, if you remember the furor, the apoplexy of people over the Quail Competitiveness Council, another time of despair for those worried about the legitimacy of the regulatory process. So it reminds me of people that talk about every presidential campaign as the worst, the nastiest, the dirtiest campaign ever. I would say, go back to 1800 and read about that campaign if you want to talk about vilification, lies. Scurrilous is a good word to describe that sort of behavior that took place then. So let me talk a little bit about how the world, the regulatory world, looks from the OIRA or EOP point of view. First of all, as I mentioned, the protection of the president's authority vis-a-vis Congress is very, very important in the daily life of the staff of the White House, and this contributes to in the regulatory system in that when OIRA looks out at the regulatory panoply across the government, it doesn't see a large, complicated EPA rule that staff may have been working on for years, that stakeholders have been involved in years. It sees that, and then right next to it, it sees another EPA rule that is being drafted, and the staff are talking about it, and it sees another EPA rule that came in 2 weeks before that's sitting on the desk officer's desk, and it sees a commerce rule and an interior rule. In other words, it's this conglomeration of regulations. which, although we looked at rules rule by rule, from the point of view of the deputy administrator where I was, it was this endless stream of regulations, all of which, to somebody, were the most important policy discussion in town. And in some cases, in the EPA case particularly, some cases they were the most important policy discussion in town, but usually not. Usually there were a set of rules. EPA rules sort of rise to the top because they're, as has been mentioned, so controversial and so the effects, the impacts across the culture are often so great, and as we're going to see that in the coming months and years, and climate change. You know, you wouldn't, when FDA came in with that tobacco rule back in the Clinton administration, that was no small potatoes. People were pretty interested in that. Endangered species, critical habitat designations get people out, particularly in the West, exercised pretty well. If your goal is to exercise people with public policy, you can do it through an endangered species listing. What we tended to see was debate and argument, and that was the norm. It wasn't unusual. It wasn't, and it didn't feel like we just had to get this rule through, that the agency had to get it done. If it was going to take another 6 months added on to perhaps an 8-year development period to get better information that would better inform the decision, then we were happy for the agency to take that time. Now, yesterday, you know, I don't want to defend the 20-year period that it has taken to do the, I guess it was the steel erection rule that we were talking about yesterday. Airbags, passive restraints was one of the first rules that I was involved in when I came to Washington. First ANPRM issued in the summer of 1968. The State Farm case, still dealing with it in 82 or 3. Then I think the Elizabeth Dole's clever final decision, final rule on that was in the mid-'80s or towards the late '80s. So that's a pretty long history. I don't want to defend that kind of timeline, but I will defend a delay of 2 years, or say 4 years instead of 2 years or 3 years. So some delay is inherent in doing a complete job with a complex problem, and the voices of concern about the delays in particular rules were, this is a bit of an exaggeration, I don't want to imply everything this implies, but it was sort of background noise to the White House. Everybody's complaining in the White House. I mean, nothing comes to the White House unless people are concerned about it, and that means they're arguing, and that means they're tending to advocate with their set of facts and principles and what's obvious, and somebody else's are different, and it's a non-collaborative situation. Right? The stakeholders, the interests are not coming together to go into, if they're lucky enough to get into the Oval Office to talk to the president. They're going in and trying to hammer Rahm Emanuel with their point of view, and then he's going to listen to the other, and then the system that's set up in the same way that it works all the way from Congress up to a presidential system is that the government then repairs in the quiet of either in the quiet of its, I don't know, closet or somewhere, and makes a decision. But that is a hard pattern to break, and that's what collaborative governance to some extent is trying to do, if not at all places in the decision making, at least in some of them. So to come back to the regulatory world that the White House sees, no matter who the president is, when he and his staff look out at the regulatory landscape, what they see is the need for some selection and some restraint. There's just too much stuff going on. There's too much activity for the government with its current size, and whether that's current size as of 1981, current size now, I don't think it's actually changed all that much except for the defense change at the end of the Cold War. It stayed about the same. It doesn't appear there's going to be a whole lot more staff to do all this stuff. So the need for some selection of where the resources are going to go is necessary. And this is part of the role that OIRA plays. It's also part of what agencies do in the normal course. You're probably most of you are familiar with the regulatory agenda that's issued twice a year. That's been issued twice a year since maybe 79 or 80, long time. And if you thumb through that and look at the issues listed under NPRMs, you will see issues there with their calendars, little calendars of action, where there are plenty of NPRM issued 2001, NPRM issued 1994. I don't know if there's any 80s left, but there are some NPRMs that are very old, and they may be in the agenda. They may be listed as rules that activity is going to take place on the next year, but they've been in that position for the last 12 years. So there is some, you can infer without too much work that there is a selection process going on. It's more formal in the fall agenda when the reg plan, I guess it's called the reg plan. I could never remember. It was the reg program in the Reagan years, reg plan in EO 12866, where the agencies consciously pick out the most important, so the very important. You'll be interested, when that first went on, agencies wanted to list just about everything as the most important. They thought it was a kind of like an insult to their rulemaking confreres not to list something as important. So we wound up with a reg program that was almost as long as the reg agenda. So we had to, it took a couple years to kind of get it down to the top, I don't know, 150 or 200 out of the sort of 4,000 or so rules. Now, this issue of selection and restraint is an important one, and it starts with the fact that there isn't any mechanism in the Congress that way. The Congress doesn't operate through some kind of a mechanism that says, you know, this is an important environmental problem, but we've already given EPA as much work as it can handle, maybe for the next 10 years. The Congress doesn't operate that way. The Congress, through its magic, says there's a problem out there, we need a solution, EPA, go to it. Interior, do it. Transportation, you know, get those regs out there. And it was that sort of generation of regulation through the Congress that has resulted in various ways that the executive branch has had to respond with some kind of restraint of its own. It's easy to say, it's the law, you got to do it. All laws are the same. This is what the general counsels always say. But it doesn't work that way. If you have a relatively small office that does all the rulemaking for the air office, you can't ask those guys to do 20 major rules in 6 months, even no matter what the statutory deadlines are. I believe that in the late 80s, early 90s, somebody went back and counted the unmet statutory deadlines that EPA was under, and it was phenomenal. It was 600 or 700, and they tried, you know, they worked to try to get those underway. But basically, the selection mechanism was the environmental community got together and sort of decided which rules to sue on, to take them to court to get a court-imposed deadline, and EPA and we too didn't mess around with judicial deadlines. That those got met. The rules weren't necessarily complete or as good as they should have been, or as good as they might have been if there'd been a collaborative rulemaking, but they were nonetheless forced. This sort of back and forth in the amount of regulation that leads to delay has you can look at the last 4 decades or so as a sort of a push-pull between the Congress and the presidency. The 1970s, tons of new regulations, new agencies created, new statutory authorities. 1980s, President Reagan comes in, says, I've never seen a regulation I liked. All rules are bad. Let's stop things. Let's go back and look at the existing stock of regulations and cull out everything. So we did that. Like for the first of 6 times that we did this, every administration wanted to go through this sort of cleaning house exercise. When we did it with with Vice President Gore's new NPR, one of the measurements inevitably is pages in the Federal Register, pages in the CFR. So although everybody recognized that was a stupid measure, it was extremely easy, so it stayed as a measure. And I remember talking to Neil and others at EPA, and one of the ways that agencies met their regulatory reduction quotas was they eliminated all the blank pages in the Federal Register and in the CFR. And where you had a section that was only half a page, they moved the next section starting so there wasn't a half a page of blank space. And that magically we were reducing regs by 5 or 10%. That helped 5 or 10%. So my point here is that that there isn't any easy restraint that on the work that the executive branch has to do, and that means that the agencies and the president have to do it themselves, and along with these external factors that I've noted, like judicial deadlines. So one of the things I was thinking about, particularly after Lisa's talk yesterday, was would there be some way to apply the collaborative mentality to Congress itself? I don't think so, but it's an interesting thing, to think about. Being a presidential guy, I can say this: those guys up there on the Hill aren't very good at getting their act together, and they hate to have to apply to themselves the same restrictions that they're happy to apply to others. And I could see a collaborative governance legislation coming out of the Hill that affected the entire executive branch, but was the furthest thing that the Congress wanted to impose on itself. But if nothing else, as a thought exercise, it would be interesting to think about Congress organizing some sort of collaborative body to at least pick out the top, 6, 12, 20 regulatory issues that it wanted the executive branch to work, and sort of started that collaborative process, the idea of stakeholders coming together. I think you could argue that the best incentives for stakeholders to come together could be created by Congress saying this is the way we're going to do it, just as it's been discussed that happens in a real a collaboration where people have to buy in and get used to the idea that they're going to be part of a solution. I want to make a couple of other points about collaboration that are a little bit difficult. I wonder what happens to the no regulation option under the collaborative framework. That is, could collaboration be applied to what Lisa called the upstream, the design part of a regulatory framework, so that if there was appropriate authority or discretion, that the government, through a collaboration, could decide that it didn't need to regulate. That's pretty hard to do. It's pretty hard to do. But that's something to think about. The last problem I want to raise is the one of information, which has been also been raised a lot. And the question, there's two questions. One is the problem of educating a group of collaborators so that they have enough information to make a legitimate group decision. And some of those of you have described just how difficult it is to get people educated in the positions of each other. But it's also difficult, I think, it's difficult for a group to have the information it needs. And that's what regulatory impact analysis really is designed to do. It's designed to, not in a collaborative way, but to provide information to the decision makers so that they're able to decide. Now, it hardly ever gets done that way. It's always done as part of as a place in the decision-making process that's already moved far along. But it would be, but I'm thinking of how, in a collaborative process, who would be responsible for doing that sort of hard, grinding analysis that's needed to provide the stakeholders and members of the collaboration with the information they need, in addition to what they already have and the positions that they bring to the table. So with those thoughts, I will stop.
Thank you, Don. I guess David's going to go next after a little group discussion here.
Demonstrating our flexibility. Okay. As co-director of the Center for the Study of Rulemaking, I want to extend my own belated welcome to all of you. And thank Phil and Jeff for taking the lion's share of the work with regard to putting the conference together while I was enjoying myself and luxuriating at City University of Hong Kong. I have a paper here. It's titled Administrative Law and Culture for the U.S. Collaborative Governance State. It's co-authored by Mei-Jen Huang, who is sitting down there. Mei-Jen is listed in the paper, which will be available to you. I brought several copies. You can pick them up later. Mei-Jen is listed as a doctoral candidate, but on Tuesday she passed her PhD dissertation defense with flying colors, and so her candidacy is almost at an end and will be next month. One great thing about being a doctoral candidate who is defending one's dissertation is that that's probably the point in life where one knows the most about the literature one is dealing with. And her topic was citizen participation in environmental justice administration. The paper itself deals more with what Lisa mentioned yesterday, one facet of collaborative government, which is really third-party government networks, outsourcing, privatization. It's really interesting to me because I kind of have a foot in both the legal literature and in the public administration literature, how we often use the same words, but we're not really talking to each other. And I would just say that those of you who are coming from the legal side have a huge advantage in that you could find out more about how public administration treats collaborative government by going to simply one journal, the Public Administration Review. I'm not saying that's our only good journal in any way, but it is in many respects the most comprehensive that will pick up the current trends. Those of us who are on the public administration side are stuck with, I have no idea how many law reviews with all those footnotes that we're all familiar with. So to start off with, if you think of collaborative government in terms of the networks and third parties, privatization and so on, it's at least plausible that public administration has undergone a paradigm shift since the 1980s in which and this is really global, in which we do rely much more on non-governmental entities to deliver public services. This is often put forward in the metaphor of government should steer while others should row. Government should arrange for the delivery of public services but doesn't have to deliver them itself. You could date, in terms of the public administration literature, this paradigm shift, if it is one, but anyway, a new way of thinking about things, from E.S. Savis's book on privatization, The Key to Better Government in 1987. Now, of course, the key, if we went around the room and asked everybody, what is the key to better government? Of course, there is no one key. But he did forcefully put forward the argument that really to return government to its proper role requires government arranging for the delivery of public services and constraints, and not necessarily delivering those constraints and services by itself. Savis's book was greeted with some skepticism at first because he listed a whole range of functions which traditionally had been thought of as governmental. Just a few of these, just to mention a few: economic development, crime prevention and patrol, child protection services, crime laboratory work, adoption services, public relations and information services, among others. But in time, we've come around to the point where we do outsource a great deal. Rena yesterday mentioned the hollow state. I think one marker of the hollow state is that in the 1990s, the Department of Energy actually outsourced its IG functions, which is in many respects, I think, quite startling. Well, following Savis, we had David Osborne and Ted Gabler with a very phenomenal book, Reinventing Government, which really put a name on many of the things that we now refer to as collaborative government. That book, and David Osborne in particular, informed to a great degree the National Performance Review in the Clinton-Gore administration. So many of those ideas went forward, and they repeat the steering and rowing metaphor. By really the midpoint in the Clinton-Gore administration, it was reported just on this hollowing that the Department of Energy had about 15,000 actual employees and 100,000 employees on contract. And that gives you an idea. This is a hollow state. How can 15,000 people possibly manage the 100,000 contractors? We went even further in the Bush administration. The president's management agenda looked toward competitive sourcing as a mechanism for governance. And we'll see what happens with President Obama. He has expressed some skepticism about OMB's Circular A76, which is essentially the rule book for outsourcing. Now, turning to why do we have this third-party government? What are the purposes? Just list a few, because it's often assumed that better government means cost-effective government, and that's really what Savis and I think the National Performance Review meant to a large extent. National Performance Review perhaps looking at better government is also involving citizen trust. Well, in terms of purposes, cost-effectiveness is clearly the primary purpose. It's clearly the number one reason for outsourcing in the United States. And the argument's usually put forward that, look, why should government make its own paper clips and pencils and so forth when you can just buy them on the open market? Well, then you go down that famous slippery slope to IT services, probation services, and almost everything else, or a lot else, on the same logic. If it's available in the private market, the private sector, and there's competition, why not take advantage of the competition? You'll probably get better service and a better value and at a lower cost. And we can debate that. So the empirical literature actually doesn't show that that's always true. It shows a very mixed pattern with regard to whether we do in fact get true cost effectiveness. But being over there in Hong Kong, I realized fairly recently that cost effectiveness is not the only purpose of outsourcing, because they outsource in China. They're doing all this in China, but they don't have the kind of competitive market we have. So the government agency outsources to a state-owned enterprise, and there's only one state-owned enterprise. So how are they going to get cost effectiveness? Well, that generates some thinking, and it turns out that there are really some other reasons for outsourcing that I would say are certainly equally important and probably explain a great deal with regard to some outsourcing decisions. One additional purpose is specialization. It may well be that it's not a question of cost effectiveness so much as getting the capacity, the specialized expertise and the capacity to do something which is hard for one reason or another for the government itself to build. I guess a fairly good example would be information technology. You've got all those firms out there that specialize in public and private sector IT. Why would government seek to actually duplicate that when it's available on the open market? And it's not, again, it may overlap cost effectiveness, but what you really want there is the capacity that would be hard to build. Another purpose is subsidies. And I would point to the Bush administration's faith-based initiatives on this score. Whether one is in favor of that or not, it's very clear that outsourcing with regard to faith-based organizations is one way of funneling federal dollars into the faith-based organizational community. A darker side of this is to circumvent legal requirements. I'll come back to this in a few minutes, but it's completely clear that the Constitution rarely applies directly to private parties that do government work on government dollars, taxpayer dollars, etc. And most of the administrative law regime simply doesn't apply to private parties doing government work, at least at the federal level. An example here was in 2006, the Department of Defense contracted with a contractor that then, a private contractor that subcontracted with a company called Be Now Incorporated, which was to create a database on high school and college students as a tool for recruiting, military recruiting, getting information on birth dates, social security numbers, ethnicity, grade point averages, and the student's curriculum. But also, the DOD authorized the contractor to gain access to the student's medical records. Now, most likely the DOD couldn't have done that directly itself without violating possibly the Fourth Amendment, the Privacy Act, and there must be much more that's out there that many of you know about and I don't. And then a final purpose that I'll mention is politics. And this was just very clearly the Clinton-Gore administration. The New Democrats had to show they were different from old Democrats. The old Democrats were labeled as tax and spend liberals, big government types. What Clinton and Gore had to do was to reduce the size of government. One way of reducing the size of government in terms of head count is, of course, to outsource a lot of governmental functions. And indeed, they did reduce the head count of federal FTEs by at least 280,000. They also, a New Democrat has to distinguish himself or herself from Republicans, and that was fairly easy for Clinton and Gore because they took the line that government can be a positive force in society, and unlike the Reagan Republicans, government was not seen as the problem, but rather as part of the solution. But it's really clear that a lot of the federal level outsourcing, it has been driven by politics simply to keep the number of federal FTEs down. Now, there are at least three significant issues that are generic types of issues or concerns with the collaborative government in this sense of outsourcing. One is the definition of inherently governmental functions, another is legal controls, and the third is corruption. With regard to inherently governmental functions, what's happened is, and I think it's fair to agree with Paul Light on this is that, I'm quoting him now, but for a handful of functions dealing with national security and criminal justice, it's not clear that there are any purely inherently governmental functions left today. And that, I think that's pretty close. Savas, when he was first writing, said there are all these false alarms raised about privatizing services that are said to be inherently governmental. The responsibility for the service can be retained by the government, but it can be delivered by some third party. And incidentally, those of you who come from the legal community, you may quickly notice that in public administration, we talk about government as public service, as serving, whereas, when you talk about regulation, and from the legal side, it's constraints. And we rarely, in public administration, actually view the constraints. Well, I could go into OMB's definition of inherently governmental, but it's guaranteed to create a brain freeze for everybody. But we can, if you want, we can do it in the Q&A period. It's almost impenetrable what is exactly inherently governmental and what is not. The Obama administration has asked OMB to take another look at its definition and come up with something that's clearer, that is more crisp and less blurred. On the legal controls, another generic problem, as I mentioned, when we outsource, the Constitution doesn't apply except under two conditions. One, of course, is the 13th Amendment, which thankfully is irrelevant, prohibiting slavery and involuntary servitude. The other is in terms of state action doctrine. So sometimes a private party does become a state actor for constitutional purposes, and we can talk more about that too. But state action doctrine, by the Supreme Court's own admission, is a matter of normative judgment, having criteria that lack rigid simplicity and consistency. So if you want to apply this in advance, you don't want to do dog law, after the fact get pounded. You want to do this in advance, it's kind of difficult because it's a question of normative judgment, which really means 5-4 on the Supreme Court, and who can be sure exactly how that will come out. There are some general guidelines, of course. Public functions will, if one's engaged in a public function, will often make one a state actor. If actually the organization is controlled by the government, if it's engaged in joint participation with government or entwined with government, it's apt to be a state actor. But let me just say that for the Administrative Procedure Act and many related types of statutes, we have the same problem. They were adopted to regulate government agencies, and they don't generally apply to contractors doing the same work that government agencies have done. There are some exceptions. The Open Government Act of 2007 does have some application with regard to maintaining records and making them available under Freedom of Information for contractors, and there's something called, which you all know, I think, the Federal Acquisition Regulation, which does incorporate some aspects of the Privacy Act and some other aspects of administrative law. But this really makes a huge difference. I'll just give you two really quick examples. When the Space Shuttle Columbia disintegrated, the media and lots of interested parties used the Freedom of Information Act to get some information about what had happened. Well, of course, NASA put up a website and did a good job saying these requests have come in, and this is where they are in terms of what we're doing with these requests for information. But there's a private contractor that was a partner with NASA, United Space Alliance, made up of Lockheed Martin and Boeing, which is private, to which freedom of information just simply doesn't apply. It is said that United Space Alliance, conveniently abbreviated USA, United Space Alliance did 90% of the launch work. That doesn't mean we lost 90% of the information, but obviously a lot was not immediately available. Eventually, it came out with a Columbia Accident Investigation Board, but that was just an extraordinary event. So when contractors do government work, this example just illustrates you can't, if you value transparency, you've lost it. You know, it's just gone. Another quick example. In Kentucky, they outsourced at-risk child services. So this is essentially a kind of social work to deal with children who are at risk. They outsourced this to a group called Kentucky Baptist Homes. Kentucky Baptist Homes had an employee who was photographed at a state fair with her arm around another woman in a somewhat suggestive pose, indicating that she might be a lesbian. Kentucky Baptist Homes fired her once the photograph came around, on the grounds that her behavior was inconsistent with the Judeo-Christian values that Kentucky Baptist Homes is organized around. Now, you know, it might be nice if some agency were organized around Judeo-Christian values, but I can guarantee you that no agency in the United States can constitutionally fire somebody for not being in tune, simply for not being in tune with those religious values. And then we come to corruption. And, you know, here the opportunities for corruption are just expand dramatically when we outsource. And, of course, we've had lots of reports on corruption. A lot of money changes hands, and there's not adequate contract monitoring. Consequently, some of that money goes to places where it probably shouldn't go. The federal government has something called an excluded parties list system. And this is a list of now 70,000 organizations and perhaps individuals to whom the government should not easily contract out with, okay? But apparently, according to the GAO, this isn't working too well. Recently, they had a report, and it turned out that one of the listed companies received a contract after it tried to sell nuclear bomb material to North Korea. The reasons, there are systematic reasons for corruption, and I could refer you to principal agent theory, which is just pretty clear on this. There's the whole problem of information asymmetry. The contractor probably has more information about what it actually costs to provide the service, how the service should be provided, and so on. It's hard to monitor. And then you have the problem of moral hazard. Anytime you're dealing with other people's money, it's fairly easy to spend it. A Google search of, quote, corruption in federal contracting yielded 244,000 results. So I think the case is probably made. Okay, now, Lisa yesterday mentioned that maybe we need a new statute, and I'd like to turn to that just really briefly. It's hard to remember that when the APA was enacted, it was considered a Bill of Rights for the hundreds of thousands of Americans whose affairs are controlled or regulated in one way or another by agencies of the federal government. The APA was not seen as the avenue for ossification and malaise and everything else. It was seen as a protective statute to harmonize the administrative state with U.S. democratic constitutionalism. So now we really have to ask ourselves, I think, and Lisa raised this point yesterday, if we have identical work paid for with taxpayer or deficit dollars, subordinated to administrative law when a government agency performs it, why don't we subordinate it to some kind of democratic constitutional controls when a contractor does exactly the same thing? You know, when United Space Alliance does exactly what NASA could do, why don't we demand that freedom of information apply to United Space Alliance if we value freedom of information? Interestingly, Circular A-76, the rule book for outsourcing at the federal level, pays no attention at all to these democratic constitutional values, except in a very narrow way with regard to how it defines inherently governmental functions. No value whatsoever is put on freedom of information. And it might cost an agency more to have freedom of information than a contractor who doesn't have it and therefore comes in at a lower price when you competitively source. So that's something I really think we need to think about. And of course, the usual response is, well, if we raise the cost for contractors, then outsourcing won't be as cost effective, and why do it? And that's probably true in many cases, but we still have to say, do we want to have these democratic constitutional values or not? And in some cases, I would say, such as prison administration, probably the fact that Correction Corporation of America and Wackenhut are seen as state actors when they're engaged in prison administration, because that's a public function. Probably that makes outsourcing prison administration, prison management, more palatable politically than otherwise. Certainly if we could just avoid the Eighth Amendment and have as much cruel and unusual punishment as we wanted, if we outsourced, I think we'd probably get some pushback saying we can't outsource this particular function. Okay, now just turning briefly to what's essentially Mei Zhen's section of the paper that kind of fits fairly well. What kind of, not legal changes, et cetera, but what kind of administrative culture changes would we need for collaborative governance? Many of these elements were mentioned yesterday, so we can go pretty quickly. But first, we need to adjust administrative structures and processes. When you have the collaborative governance state, the way I'm describing it, the third-party administration, what you have is a horizontal structure. If you ever had command and control in the separation of power system, it doesn't work when you're outsourcing. The structure is horizontal, and therefore the skills need to be a little bit different. You can't rely on a chain of authority, but you need to bargain much more. So you need bargaining skills, and as was pointed out, for rulemaking, you need to have quasi-legislative and quasi-judicial processes. Second, was mentioned also, we need to improve citizen trust in government. However we do that, it is a fact of life that there are many private organizations that simply don't want to deal with government because they don't trust government. So when we outsource, we have a smaller market, so a smaller segment of the economy that's willing to engage because of a lack of trust. We need different skills for collaboration. Communication's really important. Negotiation's important. We need to adjust personal administrative attitudes and organizational values, especially to get used to sharing resources and sharing authority. The idea of sharing authority historically has been something to which public administrators have been opposed. It's almost been seen as illegitimate to allow third parties to have some role in determining how policies are made and implemented. We clearly need, this was mentioned yesterday too, we clearly need much better assessment tools for determining whether collaboration in any sense works. Are we looking at outcomes? Are we looking at processes? Are we looking at both? And what are the outcomes and processes that we're looking at? We probably need to increase bureaucratic representativeness, which we now call diversity, but from 1944 forward in the PA, public administration literature, we call it representative bureaucracy, because that overlaps citizen trust and building legitimacy insofar as we're aware. We need more institutional support for collaboration. And then, as Rena mentioned yesterday, look out for the dark side of collaborative government, which involves co-optation, imbalances in resources and power, and I would add a fair degree of temptation for corruption. Okay, to just wrap it up, I think what we really need to do for the collaborative administrative state now is to think in terms of a new administrative procedure, act, or regime. I know that probably sends shudders down lots of people's spines here. But, if Kenneth Culp Davis and the others could do this from 1940 to 1946 for the traditional administrative state, which was new at the time, why can't we take on a similar task? To me, it simply makes absolutely no sense that we have this administrative law regime and also the constitutional law regime, which may lead to ossification or whatever, applying to government agencies, but when the same exact work is done by private parties on the same exact taxpayer dollars or deficit dollars, most of it doesn't apply. To the extent anything applies, it's incremental thanks to either legislation or judicial decisions. People in this room, people who are interested in collaborative government, haven't really, in my view, played a very substantial role in trying to prescribe what the legal regime for the collaborative administrative state should look like. Thank you.
Thank you very much. I'm tempted to ask some questions now, but I'll hold off. Bob.
Well, good morning, everybody. This is an honor for me to be here. A week ago, I gave a paper at a conference in which everyone was an economist, and I'm a political scientist. So I thought, what would be the next logical step for me to take but to make a presentation in front of a group of attorneys and people who have been involved in the regulatory process. The next challenge came when David Rosenblum called me at the last minute and said, Paul Light may not be able to make it. Do you think you could fill in for Paul Light? And I said, myself and how many other people might fill in for Paul. And so I thought, why not go for the troika today? And as we adapted the line on Jeff here, I thought, why not go after David Rosenblum and his presentations along with Don? So that's the challenge, and I'm just really happy to be here. I'm going to take a little different cut on collaboration. And there may be some overlap from what I can tell. We were involved in a NASPA site visit yesterday, so I wasn't able to attend some of the sessions. So I've got a PowerPoint for us, and that will be made available to everybody. And I think there was talk yesterday about posting those. So that will be available. So I'm going to try to work my way through there. There's a person we hear in the press a lot today, a name that we hear, and it's Herbert Hoover. And I'm going to talk about Herbert Hoover in a little different light. I'm going to talk about Herbert Hoover just to begin with, to frame my argument today. As Herbert Hoover as rock star, as Barack Obama of the 1920s, when he was known as the great humanitarian. He was known as the great engineer. The Democratic Party and the Republican Party in 1920 toyed with the idea of having Herbert Hoover run for vice president. FDR recommended Hoover to be on the vice presidential ticket in 1920. And where Hoover was getting fame, of course, was he was also known for being his humanitarian efforts. But Hoover had also written a book called American Individualism in 1922. And New York Times book reviewers said that this book would go down with the Federalist Papers as the most significant work on political theory in the United States history. I'm sure you've all read it and paid a lot of attention to that book. The reason I raise that is Hoover was the representative of kind of a forgotten wing of the Progressive Reform Party and as well as a basis of regulation. And Hoover was involved in what he called associationalism. And the idea was he saw it as kind of a third way between centralized government and a powerful centralized government in Washington and rugged individualism. And he saw a very unique role for government. What he saw was the idea that government would collect information. It would send that information to the public. He would use the press. He would use the media. He would use conferences of bringing business persons together, attorneys, the best and the brightest, and that they would essentially set rules and regulations. And this was an intriguing idea. He put it into practice when he was Secretary of Commerce during the 1920s. He was probably an administrator who was the top administrator in the country. He was known as the Secretary of Everything at the time, during that time. He was the voice of progressivism in the 1920s. We look up, of course, and we see him in a different light today, and we look back at associationalism, and we wonder what the consequences were. That is, some of the consequences were indeed self-regulatory cartels. That is, his faith in business to collaborate and to work on regulations quickly turned into an exercise in self-regulation, some corruption, and some other things that my colleagues on the panel have talked about. So my question today is, as we look at some of the partnerships that are evolving, and I'm going to focus a little bit on the environmental arena, my question is whether or not collaboration is the new associationalism, that it is back, and the question then becomes, are we engaged in, as we begin to move much more into private-public collaboration, are we on the road to what Hoover came up with, or what the result of the original associationalism was? So that's kind of one takeaway. And my argument is going to be, and my colleagues on the panel have already raised a couple of possibilities here with you, is without transparency and without measurement and without a great deal of oversight into those areas, self-regulation doesn't really work. And it goes on the road very quickly to not only a potential for mischief, but also the exclusion of ordinary citizens in the process, and some of the democratic values that David mentioned. So that's one takeaway I want us to have as I go through this. The second question is, can you really have collaboration in a system, in a Madisonian system that's designed for distrust and mistrust, and for identifying the faults of others in that process? I think Don was getting a little into that in terms of his, I guess, apparently some of your conversations yesterday. This is a system that pits one individual and groups of individuals against another. It's ambition against ambition. And all of a sudden, we're moving towards collaboration, which then causes us to put things aside. My question is, and the takeaway is it possible to do it? And my answer is going to be under certain conditions. And I think you may have heard some of those conditions yesterday, but I'll give you my version and my take on that. The last question, or the last takeaway that I'd like you to do, is to start thinking in a different way. I did a book on the administrative presidency several years ago, and I talked to a person in Region 9 who was the district administrator. And he was a leader in collaborative government out in his area, out in Washington. And I asked him, how do you do it? And I hesitate to say this, but he said, the first thing is you get the lawyers out of the room. And you begin then to decide how to put together a collaborative exercise, and then bring the attorneys in and begin to work on that effort. And that really struck me as really a really interesting comment. I think we've got to take what he was doing, in effect, is what we call in political science, public administration, moving from a top-down perspective to more of a backward mapping perspective. That is, starting and trying to eliminate some of the complexities, not just of the law, but the complexities of the Madisonian system itself. So those are the three takeaways I'd like to have you take away from the meeting. And now I'm going to try to work our way through here a little bit, if I can work this gadget. Notice I call this networking in the shadow of hierarchy. And I think that's essentially what we're all trying to do as we move into partnerships, public, private, nonprofit partnerships. And we're trying to essentially bring people together and network, but those regulations, those categorical grants, those other elements that are so much of a part of our life and our existence and our world as we've developed it in the administrative state, they don't go away. And so this, I think, poses the really fundamental challenge. Why collaborative governance? I've listed a variety of things here, and here I'm talking basically in terms of environmental policy, but I think it applies in a variety of ways. The argument is the nature of the problems have changed. That is, no longer can we have single agencies and single programs dealing with problems. Problems interact. We have very crowded policy spaces. What is the poverty problem in the United States? Well, regulations dealing with transportation, housing, a variety of other areas come together, so that the idea of looking through one single lens and through one single agency, and even through one single discipline, the argument is made we simply can't make policy that way. A colleague has called it, the idea of trying to have collective puzzlement on the part of society. That is, no rule or regulation in isolation can be looked at. We need to puzzle and put this together. So one of the arguments is the nature of problems have changed. We can't go back to single stovepiped agencies in this crowded policy space. And we've seen Obama create all of these czars, these czar positions. And we know the history of those aren't very good, but I think it's probably reflective of this crowded policy space and the idea of somebody's got to try to break down some of the stovepiping between and among the agencies. And again, I want to emphasize, these aren't bad people doing these things. These are people who are acting rationally, and perhaps there's collective irrationality at the end, but people are acting quite rationally given the system. Stovepipe agencies. I also argue that there's downward pressure on the visible side of government, and this is my tribute to Paul Light, who has educated us all so long on this, and that David mentioned. But I take it a little further. I think with globalization, there's a downward pressure period on the visible sides of government. We have to hide it. And so one of the ways we hide it is to do what Don and David have suggested. We begin to push responsibilities upward internationally. We push them downward to states and localities. We push them outward to nonprofit organizations, and we push them out to private organizations. So I think there's a fundamental dynamic to add on to David's list, and I think there is a fundamental driving force from globalization. We vote every 2 years, we vote every 4 years, the markets vote every day, and there's money transfers across boundaries, and I think it's a different world than the administrative state and the Administrative Procedures Act was created for. Cost of adversarial legalism. You've probably talked about regulatory negotiations, et cetera, but the cost, the legality cost, another reason. The last, negative interpretive effects. What political scientists and public administrationists are finding out is that what you and I do as public administrators and regulators, et cetera, has an impact on how citizens see themselves. That is, they can see themselves as either part of the process of rules and regulations that affect their lives, or they see them marginalized by specialists like you and I. And we look up after the New Deal, we look up after the Great Society, we look at everything that we did with the best of intentions. And the argument is that citizens feel marginalized and inefficacious as citizens. And it's an expert administrative state that's grown up. And so part of the idea of collaborative government is to try to get those citizens back involved in the process. And so much of collaborative government stems from a bottom-up approach where, as DeWitt John has pointed out in the environmental area, environmental civism. Where you try to patch together everything we're doing in Washington, and you try to bring it together in a regional area. And you try then, and oftentimes we find citizens like Barbara Mikulski, who was a neighborhood organizer, coming from the bottom up and now is in the United States Senate. So there are a lot of reasons for doing these kinds of things. In the environmental area, I'm just listing up here for you. I won't go through these. You're experts in so many of these areas. But there are a variety of ways that collaboration has taken place beyond regulatory negotiation that brings to bear the needs that we're talking about. We can have the voluntary programs, the Energy Star programs. We can have voluntary and cooperative R&D programs that are really, my argument is, in terms of my writing, are really reflective of this associationalism. We can have pure information-based. We can have self-regulation. Increasingly, in a global world, as you all know, in a global world, you have associations that are put together, and they're trying to self-impose regulation, fearing the club of what we have. And so you have those kinds of efforts going on. It's starting to look like Hoover, okay, in terms of self-regulation. And then, of course, you have, because of the crowded policy space, collaborative interagency regulation. Obviously, I'm not going to go through all this. There are generic challenges, though, and I'll just highlight a couple of these in the time that I have here. One is the challenge of collaboration, and it gets back to my notion of networking within the shadow of hierarchy. There is what's called intercurrence between and among regulatory statutes, and all that means is that in the environmental area, you have kind of 3 or 4 eras where statutes don't go away and the rules and regulations that we've issued don't go away and they're still there. And so that anyone who wants to challenge collaboration can find his or her favorite statute to go by. Right? So if you're the Clinton administration or the Obama administration and you want to reform natural resource management out west, the opponents can go and find a legal basis for saying, no, you can't do that because we have X law on the books that says we are to promote production. So you have this intercurrence of statutes and you have intercurrence of rules and regulations. The advice is, sounds easy, advice is to integrate collaborative efforts with statutes. In other words, right, to begin to put those together. Otherwise, people are going to be very rational and they're going to cling to the safety of those original statutes. It's just easier to run back, if it's a risky situation, to a statute or a rule or regulation when things get tough and things get tight. The transaction costs are immense, and I think people have talked about that, and you folks are in that field and know the transaction costs of trying to make this work. Because part of the advice here is, in collaboration, is you've got to manipulate those transaction costs to bring the deal together. In other words, you may try to impose higher transaction costs in order to get collaboration to bring it in. Collaboration is not a game for the meek, the impatient, the politically unastute, as you try to do this. You've got to have a hammer in the closet as well, and you can see the Obama administration, I think, on the Clean Air Act holding that up, with Lisa Jackson going full force ahead on the Clean Air Act, and the White House talking about cap and trade, and the linkage is very clear. We can do it this way with markets and exchange, or we could enforce this through the Clean Air Act and your life will be miserable. So you got to have that club in the pocket, and that tends to be a commonality, at least that I've found in terms of my reading of the collaboration area. Measurement, outcomes-based measurement, and of course we've all been through this. My colleagues have mentioned NPR, etc. The idea of managing for results. But I think one thing we learn is we have to learn through the collaboration process. If we're not learning, then we're not getting anywhere. So if we just measure something, and we get a measure, and we don't link it to process, that is how you got the measure, then we really don't learn, and we're not engaging in collective puzzlement on behalf of society. We're going to run back to our statutes and our rules and regulations. So what I like to emphasize is, to our students, is to link those outcome measures, because I think it's a better conversation to have than the old conversation of, we got 3% last year, inflation's gone 2%, give us 2% more and we'll do good. I think we need to have a conversation about what difference they're making in the lives of the folks who are affected by their programs. So, but I think you've got to link it to process. I also think those measures have got to be smart, they've got to be specific, they've got to be measurable, they've got to be meaningful to other stakeholders, I think. You know, there's a tendency in the measurement field to see this as a stick, right? That as soon as the Bush administration put out their red light or their green light or their yellow light, but especially their red light, that was a problem, and then immediately congressional hearings and the poor agency gets clobbered over the head for this red light. There are other ways to use measurement. And the part of this is the learning process. And I think what you have to do is you have to understand that you have various stakeholders, and different measurements matter to those different stakeholders. So as you're engaged in collaboration, it seems to me what you need to do is look to your north. What matters most to people on that congressional oversight committee or oversight committees? What do they care about? And measure in that terms. To my south, what matters to my subordinates? What matters to my enforcement agents who are on the front lines every day while I'm safe here in Washington, making rules and regulations? I think you need to look to what matters to them and measure that way. And you see what you're doing, you're creating a constellation of political forces around the collaboration effort that brings you both accountability, but also brings with it, I think, at the same time of accountability, it begins to create a climate of political forces around it. People start to care about your program. This whole thing is about bringing the audience who cared originally about those programs, bringing them back into the fight, because it is a fight. You know, you issue regulations, you've got to enforce them. It's a fight. The audience, when you pass a rule or regulation or a law, the audience doesn't go, they go away. It's a 24-hour news cycle. You've got to call them back into the process. And I think that you can use measurements for that as a political tool and a motivational tool, but also as an accountability tool to bring people together to do these kinds of things. Obviously, from what I'm hearing in the conversation, you've talked a lot about collaboration as conflict and conflict management. And I want to mention at least two books that Lisa Bingham has written with a colleague of mine, or a very good friend of mine, Rosemary Leary. If you want to go to one single source to get the idea how to do this, David has the book, and he can maybe hold it up down there. This is the single source if you're really interested in how to do these kinds of things, because I'm not going to have time. You got to understand, this is a perpetual campaign if you're in your collaboration. What you're trying to do when you collaborate is you're trying to persuade people that what they saw before and decided not to take action on is now important, or they couldn't do it. So you're trying to build momentum behind this program. And like all systems in a network of collaboration, entropy is the process. It runs down. And we tend consistently, looking down from Washington, top down, we tend to look consistently and design programs and regulations that that need extraordinary effort on the part of highly talented people working very, very hard over long periods of time to make it work. And the implementation literature tells us that's the wrong way. If you design a program that requires that kind of effort, you can look forward to enforcement difficulty. So what they counsel again is it's a continuing campaign of marshaling resources, of trying to keep the focus on the original problem, drawing the audience back in, using the measures, milestones, linked to process, linked to outcomes, okay, and being sure about those outcomes. I'm going to move on to the next, and again, I'll make this all available. The sticks and carrots we've talked about. There are reasons. Again, these are not bad people. In other words, they're in the Madisonian system, as I said, and they're going to resist, and they're not going to move quickly to do things. And I think Don was getting at some of this point. It may not be bad that they're delaying. In other words, we may not know here in Washington, or if we're dealing in a state capital, we may not know what's good in Crofton as opposed to Annapolis. And so delay is not necessarily bad in terms of this. The system is designed to move slowly. It's designed for you to create, and us to create, successive majorities to get things done. A lot of people got to believe that it's the right thing to do. And the Madisonian system of checks and balances, separation of powers, which David summarizes in his paper and Mei Jing's paper so well, is so apparent. So these are rational actors involved in that particular climate. There's also the whole notion from a historical perspective is we're not just trying to network in the shadow of hierarchy, we're trying to network within established networks. Right? We're also trying to get them to network within established networks. Over time, when a new policy comes down, because of crowded policy space, folks in the field have already established networks. They're collaborating in a variety of ways across those policy fields. They've developed informal networks, ways to get things done. Right? So they're already invested in a system. So we come in with a new regulation, a new law. They're going to look at it through that lens, and they're going to say, it took a long time to get the understandings we have going now to make this system function. And you're asking me to take a leap into a new world of relationships. And that's a challenge. That's a huge challenge, and they're going to be reluctant to do it. There are high fixed costs. There are coordination effects. There are self-fulfilling expectations. I know what to expect from David. David knows what to expect from me most of the time. Right? So we have understandings. We have self-fulfilling obligations. And so when we come in with new ideas about collaborating in a new way, this is risky business. This is a new world. And so their reluctance is palpable and has to be addressed. I'm going to make two last points. There's also obstacles. Oftentimes, our central administrative offices are the major obstacle to getting folks in the field to collaborate together. That is, they may want to, but they may be getting resistance in terms of hiring. They may be getting resistance in terms of information technology. They may want to do what we want them to do, but they don't have the resources or the ability to get it from central administrative units. So what we see as obdurance and hostility is oftentimes a factor of the fact that they don't control their own environments either. Okay? So I'm going to stop there because my time is about up. The PowerPoint will be available. I'll be happy to answer questions. But I do think that it's really important to think about this notion of where does public, private, and nonprofit collaboration go, and to remember Herbert Hoover.
Well, thank you very much. I think we've really broadened our discussion quite a bit this morning. And I know you have some questions. I just want to take the moderator's prerogative to ask one or two questions. And the first one is to Don. I gather that one of the main roles of the OIRA staff is to implement presidential executive order on regulatory review. That's correct, right?
That's one of many.
That's one of many. And the executive order that I read from yesterday, one of the points of it is that agencies are directed, where appropriate, to use consensual mechanisms for developing regulations, including negotiated rulemaking. So I'm wondering whether OIRA ever saw that as part of its mission to suggest to agencies that they undertake the use of consensual mechanisms, including negotiated rulemaking.
That quote comes from, I think it's section 1 or 2 of the order. This is the Executive Order 12866, which starts with a fairly lengthy description of regulatory philosophy, and then a list of 12 or 13 regulatory principles. And I think at one time I counted something like 34 or 35 within those two sections, separate separate standards, and one of them was to use negotiated rulemaking.
It's actually in a different section of Executive Order 12866. I don't have it.
Okay, so it's one of 50 then, one of 75. And in addition to that, there's the Executive Order on Regulatory Review. There's the Reg Flex Act. There's executive orders on federalism, tribalism, children's health, takings, you name it. There's an executive order on it. There was one on the family. We were supposed to do family impact statements, whatever the hell that meant. Luckily, it was in appropriations language, and we kind of quietly let it go, and the congressman that sponsored it got de-elected, so we didn't have to worry about it anymore. My point here is that it is one of many, many sets of processes, procedures, impacts that we looked at. And now finally, to answer Jeff's question is, no, we didn't pay much attention to it.
So was I right that the OIRA staff was generally not too supportive of negotiated rulemaking?
Yes, that is correct. I think the quote that's generally used is, we hated it. There's a little bit of perhaps, overburdened staff exaggeration there, and the hatred sort of has two aspects to it. One is inconvenience, simple bureaucratic inconvenience. This hollow state that was mentioned, where agencies don't have enough staff to do even close to all of the work that they're supposed to do. The same was true of OIRA. We had about 20 people that reviewed all the regs of the government, and that was about 600 a year, and that reviewed all 3,500 Paperwork Reduction Act requests every year. So there was a resource problem. I don't think anybody really thought that reg negs were useless or didn't lead to outcomes. It was more like, oh God, it's another thing. After I go to the 6-hour reg neg meeting, there's nobody else back in my office that's reading the pile of 15 new regulations and 52 Paperwork Act requests. But the second somewhat less administrative and bureaucratic reason was that there was this concern that if OIRA was in effect participating, even if it was as a silent participator in the regulatory negotiation, then what were we going to do when the chairman of the DPC or NEC or vice president staff or chief of staff said, no, we didn't authorize that, or why is that? Since we were their agents, how are we going to bring them along in the day-to-day basis of decision making, which we felt we were doing in part.
So that makes me think that maybe a possible recommendation that we might talk about this afternoon is that there be someone designated in OIRA or appointed to OIRA to serve as sort of the in-house proponent of collaborative governance, kind of so that that person could then take off, do some of the things that the regular staff is too busy to do.
Single issue advisors don't work very well. You mentioned the history of regulatory czars. They inevitably run afoul of the people that sort of actually have the chain of command authority, and they tend to pop in and out at bad times in the process and mess everything up. My advice would be to for the administrator of OIRA and the president's staff to be more supportive and simply direct the staff of OIRA to go ahead and do this and come back to me in a month with 10 examples of how you're going to do it.
Well, we do have dispute resolution specialists in agencies, and I would think there could be somebody like that in the White House. But let me just stop there with my questions for you. I just have a quick question for go ahead, David.
Hello there.
David Batson.
Well, there we go. On this same line, I thoroughly appreciate the wonders of OIRA being the sort of judicial oversight branch of the presidency in ensuring that the various regulatory agencies are appropriately interpreting what the White House wants to see in regulations, and understand that role despite the great frustration that it has played on the part of regulatory agencies being second-guessed after the fact in many situations over the years. Right. Putting that aside for a second, given the current direction of the administration from the president himself to his political appointees, that they should use collaboration in rulemaking, what are the odds, or what would be the process to get OIRA in the state of mind that if in fact a collaborative process is used to put together a rule, there should be, hearkening back to Michael's concept last night, something less judicial oversight review when it hits OIRA? That in fact there should be some assumption of credibility when it walks in the door. That there'd be less review, by OIRA staff playing the role that you very specifically and accurately laid out is in fact their role. Is that possible to establish? I mean, how could we establish that in a way that would give some credibility to process in line with the president's direction on process?
That would be a fairly easy administrative thing to do. That is, the new executive order that's good written, that is being thought about, generated now, could simply have a provision that says something like that with some definition of collaborative. Reg neg is easy, but maybe some broader definition of collaboration that just would say the OIRA. Maybe it would say that the agency and the OIRA need to collaborate, early in the process, and then the review would only be 30 days.
Collaborate on the process that's going to be used? I mean, you're talking about the collaboration. You mentioned very accurately the problem with collaboration and participation in the process and the difficulty in collaboration on the substance beforehand. I mean, we're talking about, I don't think in just practical sense, what would be the practical discussion that would be discreet enough for OIRA to have time to do it that could lead to that outcome?
Well, I can imagine it in a number of ways. The agency and OIRA could get down and kind of think about what the government's, boundaries of the government's negotiation are, sort of come to some general agreement that of what the negotiating rules of the game on the government's part would be, and let the agency go and do that. It would be fairly, you know, I mean, one of the things we thought about and worried about was whether the group of reg-neggers or collaborators, whether they were actually, whether there was anybody there representing the public good from the president's point, what that means from the president's point of view, which is different from the agency's point of view.
Help me understand that.
Okay.
Right. Professor Farina, did you want to answer?
You know, because I think I missed what Phil just said. I had wanted to follow up a little bit on this train, but I don't want to. If you think it's more productive to do it later.
Okay.
Okay. Yeah, I was actually going to ask about sort of the orientation of OIRA given the people that staff it. And, you know, historically it's been fairly heavily dominated by economists. Now, I think we think
dominated by
economists.
Yeah.
And that John Graham broadened that to some extent. But, you know, I guess I'm wondering whether, you know, when your tool is a hammer, everything looks like a nail, whether, you know, an agency that has approached rulemaking from a very particular perspective, and its role with agencies from a particular perspective, can switch gears without a substantial change in the kinds of people who are making it up.
Well, just a quick comment, Phil. We can continue this. First of all, OMB as a general matter sees a world of economic nails. It's primarily sees the policy world through money, and because there's so many other people out there arguing for spending the money, OMB tends to be the grouchy, you know, why do we have to spend all that money? Because it's seeing everybody coming to the presidency in one way or another saying this is a good thing to spend money for. Yes, the benefits are huge, but money, you know, money. So we act, OMB, including OIRA, acts as the sort of a skeptic about all of those intense desires. As far as the qualifications and the backgrounds of OIRA staff, given what I just said, economics background is I guess important. The staff, most of the staff have public policy degrees, public affairs or public policy degrees. Usually they have some fairly strong quantitative component. Sometimes that component is statistical or sort of scientific data, and sometimes it's economics. I myself, personally, unburdened by legal, public affairs, or economics training, am a member of what Garrison Keillor might call a FEMA, the new FEMA, which is the Former English Majors of America. So I came to OIRA without that sort of a background.
Okay, we're going to go on for about 15 more minutes, so yes.
Yes, I want to take the conversation in a little bit different direction, given that we're going to circle back to OIRA and suggestions in our working sessions. Robert and David, both in your talks, you talk about the need for structuring and designing, effectively designing collaboration to build in certain constraints and counterforces to make it work. And one piece of that is this question of transparency. Although I talked about transparency yesterday in the collaborative public management setting, I frankly hadn't taken that next step that David took about applying the Freedom of Information Act, for example, to contractors. And the cost issue, of course, talking about economists, is the immediate response. So we can't afford to do that. I guess I'm wondering, to what extent have you started to play with ideas about how to finesse the cost issue? And Bob and I have had a little bit of exchange on a book that I mentioned yesterday by Fung et al., Full Disclosure, this notion of bottom-up transparency, developing systems for people to do disclosure that then creates, like Amazon's book ratings, right? That then creates the information the rest of us can use and creates the constraints.
Okay, I guess that's on. I look at this really through the federal acquisition regulation more than anything else so far. There may be many other ways of getting transparency. The Department of Energy has something called the it's DOE, DOE is the Department of Energy, DEAR, I kind of forget what it is now, but it's the regulations for outsourcing, and what that includes is that the records that a contractor develops in the process of fulfilling the contract are vetted by somebody in the DOE who decides whether they should be disposed of, whether they should be retained by the contractor, or whether they should go to DOE. As soon as the agency actually takes possession of them, they're at least theoretically available or potentially available through Freedom of Information. The Open Government Act does something similar, requiring that contractors that develop records as part of the contract have to make those available through Freedom of Information. On the cost issue, I would hit it straight on. I mean, what we do with the competitive sourcing is we look at what does it cost the agency to perform the service or apply the constraint, what would it cost the contractor, and we go make a decision. If the government can do it within about 10% of what the private sector can do or the contractor could do, then we stay with government because we realize we've got more accountability there. Why don't we level the playing field? I mean, the contractor doesn't have to worry about these administrative law type constraints, transparency among them. And so I would go at it like that and say, well, look, if freedom of information is valuable, then let's put a price on it, essentially, and let's level the playing field there. Another way of doing it is, and again, the prison administration example I think is a good one, is simply to say we value transparency, and consequently, even if it costs more, that's what we want. And I think the Open Government Act gets toward there, and the some aspects of the federal acquisition regulation begin to get there. But I guess I would just confront it straight on.
So I have a comment on that, David. First of all, just as a general comment, I think your paper dealing with outsourcing, privatization, and contracting out is a somewhat different animal than certainly what we were talking about yesterday in terms of the definition of collaborative governance. I mean, and I don't know how people feel about that. I just want to raise that. Secondly, I certainly don't think that the APA, I'm going to stick up for the APA. I think the APA was a great statute and still is, and kudos to the drafters. And I don't think it's a cause of ossification. The ossification is caused by all the things that have been overlaid onto the APA, in my opinion. But when you talk about applying the APA and FOIA and some of the other statutes to contractors, it does make me wonder. I mean, there are different types of contractors. There are the Wackenhuts and Halliburtons, and then there are people like me. I mean, I'm a contractor. I mean, I have a couple of small contracts with some government agencies, one of which was an entity in the Department of Justice that needed some help on rulemaking when they got some new rulemaking responsibilities. So for the first year, I accumulated maybe 20 or 30 hours on an hourly basis. Well, the contract's still open. Last year, they called on me once, and I devoted 1 hour to it. Well, okay, so what does that mean in terms of my complying with FOIA and the APA and all the other statutes? I would think that this should be done on a contract-by-contract basis, as maybe you were suggesting, under federal acquisition regulations, so that Wackenhut operating a prison would have to follow it, but in very small contracts where it doesn't really make sense to apply the full panoply of these provisions, there should be a different approach.
Yeah, okay, a couple of things. The kind of collaborative government I'm talking about today is different from negotiated rulemaking and the kind of collaboration people were talking about yesterday, but it's what we consider to be collaborative government in the field of public administration. There's a huge literature on this, on collaborative governance, and it is about third-party governance. It's not about reg neg. One of the purposes, as Jeff knows about the Center for the Study of Rulemaking, is to bring together the legal side and the public administration side. And it may be we're using the same words to talk about different things, but we ought to sort that out and be fully aware of it. Plus, of course, these things are connected, obviously. You do your reg neg, you get your rule and so on. Somebody has to implement it. It could be a third party. So to me, there's absolutely no disconnect. It's exactly the kind of discussion I think the center ought to be having. I'm not suggesting that the APA be applied to contractors. What I'm suggesting is that we begin to seriously think about creating a legal regime to protect democratic constitutional values in the collaborative administrative state. I think whatever we might come up with would look quite different from the APA, which was intended to constrain governmental agencies, and we never had to look at the kind of cost factor or the intrusion on private relationships. Still, I would maintain that certainly we can't allow contracting out as a mechanism for circumventing constitutional and some administrative law values. So what I'm saying is we really have to start over again and begin to think of what that legal regime would look like. We're doing it incrementally. It's not like nobody's thinking about this. The Federal Acquisition Regulation does get at this. It applies the Privacy Act, for example, to contractors. So things are happening, but incrementally, without any kind of grand design. What I'm suggesting is people who are interested in this and talented and no government and no law and no public administration should do what the center wants them to do, is to get together and think seriously about these kinds of issues. And I would say, so when we come up with it, if Jeff Lubbers has a contract that takes him an hour to do all the work, he shouldn't really be subject to a deluge of freedom of information requests. I think we can work with that based on the function, the scope, and so on. I mean, I don't think it's an impossibility. I'm not sure I would just look at the hour you spent as the determinative factor, because there may well be a CACI interrogator who spent an hour interrogating somebody at Abu Ghraib, and I might like to know about that. So I would look more toward function as well, but some package there. I mean, look, if you, the APA, I'm not saying ossified anything, but if you went back to the Walter Logan Act in 1940 or something like that, and try to talk about developing an administrative law framework for what was really a new administrative state, sure, the task would be daunting. But people did it, and you just said they did a good job. Why don't we start doing it and also try to do a good job?
Well, there was a big Blue Ribbon Commission that helped to do it, too. Maybe we need. Any other? Yes.
I don't want to dominate, so if there's anybody else, but just reacting to this question of the definition of collaborative governance, I think we need to think broadly. I want to argue again that the category of transactions that David's referring to should fall within the definition, because think about environmental conflict resolution. I mean, what happens when you get a place-based settlement with a lot of stakeholders about a cleanup? Well, some of those people who sign off on that settlement are going to have to deliver the services to carry out the cleanup. And that's just not that different. Yeah, it's a little different, but it's in the same family of things. as this third-party delivery of services. So the problems cross all the categories, and they encompass what Professor Ansel was talking about yesterday. They encompass the things we're talking about today, and we have a common set of all these processes involve voice from people outside of government participating in governance, different categories of people, and all of them raise issues of transparency and accountability, and it's just one big tent that I think we have to deal with from the standpoint of some innovation in law.
Certainly a taxonomy problem here to try to put all these into one box and divide it up. Yes.
Rich Coolin from EPA. I'd very much like to support that. In a prior life at EPA, I was one of those people who wrote regulations and submitted them to OIRA. We didn't always look at how long it took us to get it out, and with the long list, Donald, of the things that you have to comply with, we were just pleased that we got it out. At times, it was an incredible and a daunting task. The results were always good, but it was a difficult task. And EPA, being highly motivated and driven by the mission, we always look for different ways to achieve a very similar, if not the same result. Some of the things have been talked about here. We don't always do reg-neg. We very rarely do the clinical definition of reg-neg. What we'll do is we'll sit down in advance of writing the regulation, and under a FACA group, we'll come up with an agreement in principle. We'll hash it all out. Then we'll sit down and write the reg. Or we'll sit down with the stakeholders and we'll say, you know, and I think, Robert, this is what you were getting to, we can write a reg, but guess what? If we can come to agreement, we won't write that reg if you can do it. We just did that recently with lead weights on car tires, taking millions of pounds of lead off the roadways on an annual basis. So we've figured out ways to get around some of the obstacles. I don't think the results are any worse. In a lot of cases, I think they're probably a lot better. So when Lisa talks about, the definition of collaborative governments, or even the future of regulation that's being defined kind of narrowly, so I think some of the things that we've done and other federal agencies have done are broader, but just as effective, and sometimes way more cost effective.
Okay, we've got time for one more question, but Don?
Yeah, just let me respond or add to that. One of the things that Bob talked about was the need to take advantage of the networking that's already out there so that you're actually networking on networks. And one of OIRA's principal roles is a coordination among agencies, among these stovepipe agencies, for better or worse. There is a lot of expertise out there across different agencies, and some agencies are better than others at seeking out that expertise. Part of the problem that we dealt with was that even if the staffs had coordinated well with each other and with us, the political management of the agencies hadn't always and wasn't always very interested. And because the political agencies are more of a sort of a specialized country club, they don't, it's a smaller world where individual personalities can either get along or not get along. And when they don't get along, they don't want to collaborate at all. And that's where you need a president or somebody to knock them on the head and make them do that.
Okay, one last question in the back.
Hi, I'm Ann Broker from Department of Energy. I just wanted to clarify a couple of the comments you made about Department of Energy, because having worked at two other agencies before I came there, it's really a different animal in the sense that, yes, we have 100,000 contractors or thereabout and 15,000 feds, but it's always been that way. Because DOE was created, of course, from several different entities, including the Atomic Energy Commission, and the labs that the government owned and has owned since the 40s and 50s were always run by other entities. So they were government-owned facilities run by contractors. University of California ran several labs for 60 years, University of Chicago, Princeton, DuPont ran some of the facilities. That's changed over the years. And I think one of the good things is we actually do probably have more transparency than we did a number of years ago. When I first came to the department, maybe about 10, 11 years ago, people would say, oh, well, you know, feds couldn't even go onto the contractor facility. I said, well, this is crazy. It's a government-owned facility. The contractors have been subjected to more and more requirements that they report to us. And, of course, once they submit the information to us, it is accessible through FOIA. I basically take care of the contractor litigation management system. And we get FOIA requests quite frequently where we have to report out to the requester how much a particular contractor has paid for outside litigation costs. So it's just never having worked at an agency where most of the functions are run by contractors. It is kind of different. But it's also different than, like you were talking about, where you hire a contractor to do more support service contractor, or, you know, HR is contracted out so much of the classification functions within an agency. Where DOE, because of the labs in developing, building, working on various things, we have contractors doing that, and now, of course, you have huge contracts doing the cleanups from all of the nuclear waste that was created in the 40s and the 50s. So it's just, I think it gets, I was shocked when I came and go, man, how many contractors? But then when you look at the nature of what the agency does, it's just so different than most other agencies. And, you know, we're always explaining this to GAO when we're getting reviewed on why are you spending all this money. Well, let's look at the nature of the agency. So it's true. And the good news is I think we have more transparency than we had 20 years ago. But you do get into those issues of contractor records versus federal records, and they get tricky.
Let me just say that DOE is not unique, but perhaps even exceptional in knowing how many contractors it has.
Yes.
Okay, well, I think only lawyers have the chutzpah to refer to people as non-lawyers, but I want to thank our non-lawyer panel up here. They did a great job. Thank you very much.